So we are live at the Supreme Court of Ghana, where is Alexander Afeyo-Markin, who is the leader of the NPP caucus in Parliament, versus the Speaker of Parliament and the Attorney General. The case was heard a short while ago, but counsel for Alexander Afeyo-Markin was led by Joe Gatti, who is MP for Ketan, and Samuel Atachia, MP for Ebuakwa South. The counsel for the Speaker was led by Thaddeus Sori and Adam Strai, and then also the Attorney General himself, Godfrey Yeboah-Dame, assisted by his colleague Alfred Tuah-Yeboah, and a host of other members of the bench of the bar were in attendance. Now, preliminary objection was raised by the Attorney General, Godfrey Yeboah-Dame, regarding the process the Speaker and lawyers for the Speaker, in fact, had served the Supreme Court following their receipt of the bailiff from the Supreme Court on the Supreme Court's decision for the Speaker to stay execution regarding his declaration of 4 seats of members of Parliament vacant based on their intention to file as independent members of Parliament and on the ticket of the NPP. Now, if viewers will recall, this matter has become very topical in the last couple of weeks following the application by the leader of the NDC caucus, Dr. Kesalato Forsen, to the Speaker that 4 members, member for Aguna West, Cynthia Mamle Morrison, member for and then 2 other members had filed as independent candidates. Now, Cynthia Mamle Morrison had come on the ticket of the NPP to Parliament, and then the member for Suhum had also come on the ticket of the NPP. We also had a member for Honorable Aka, who had also come on the ticket of the NDC. These members had gone as independent candidates for the 2024 elections. And then the second Deputy Speaker, Andrew Samuel Kwesi, who came as an independent candidate, had also switched camps to join the NPP in the 2024 elections. Because of this, the leader of the NDC caucus, Dr. Atuforsen, prayed the Speaker to declare their seats vacant. Those seats, the Speaker, after 2 days of consideration, declared vacant. After this, the leader of the NPP caucus, Alexander Afeyo-Markin, MP for Efutu, also took a suit to the Supreme Court for the Speaker to stay execution of the matter in order for the court to also have time to determine the constitutionality of declaring such seats vacant in an upcoming election, because according to him, the constitution was not so clear on that matter. Now, when the case was heard at the Supreme Court last 2 weeks Friday, the court called on the Speaker to stay execution of that ruling, i.e., for the members to act in their capacity as sitting MPs and not have their seats vacant, as the court took consideration of the substantive matter. Now, after this, the court had to serve the Speaker notice of the ruling that they had done to stay execution. Mr. Speaker and through his lawyers, Thaddeus Sori and co, also wrote back to the Supreme Court that their service was contrary to a ruling the court had earlier made in July, whereas, as custom is, the Parliament does not sit on Mondays, and so the court had ruled that in 7 members of Parliament or the Speaker are done on a Monday. So the process that the Thaddeus Sori, lawyer for the Speaker of Parliament, had written to the Supreme Court was to the effect that the service that was done by the court was not done on a Monday, and it was in contravention of the court's own ruling. And so today, the court is sitting on the matter, but just as the substantive matter was to be raised, the Attorney General, Godfrey Abuadam, rose an objection in terms of what Tadia Story, lawyer for the Speaker Court, and in the objection, they noted that they found it rather disingenuous for they found it rather disingenuous for the court and Tadia Story to insinuate that the Chief Justice should have been privy or should have known exactly what the earlier ruling was, and so the Chief Justice, who is leading the panel, the 5-member panel of the bar, including Justice Jolene Kulendi, thought it was a bit unfortunate for Mr. Sori to make such an assertion. And so that is what has happened and transpired in court, with Mr. Sori making his submission, and after the AG had also made a submission. Now the panel headed by the Chief Justice is going in conclave and has gone in conclave a ruling on this preliminary objection that has been raised. We'll have my colleague Sarah Ofori joining me now, so that we look at what has happened so far. So Sarah, welcome.
Thank you.
So we now have the 5-member panel of the Supreme Court going in conclave. How do you make of this whole situation now?
Well, I believe this is a test of democracy. Two independent bodies, I wouldn't say at loggerheads, but in disagreement with how to interpret the Constitution and what it says. On one hand, it is being said, or the law makes it clear, that the judiciary is an independent body. So is the legislature. So as to the legislative body makes laws and the judiciary interprets the law. But we also know that before a law is made, usually the Attorney General will make inputs before it's laid before Parliament for consideration and for committee work to begin. But in this case, the Constitution is what is being tested. Parliament has its own standing orders and has made a ruling, and the judiciary has reversed that ruling. And in this case is a test in our democracy to find out how best we can move forward when such conflicting situation or right. The court proceedings is ongoing. The lawyer for the Speaker of Parliament, Mr. Alban Bagbin, is trying to defend their stance that the judiciary, Parliament is a non-judiciary body. So in this case, the judiciary has no powers or has no right, for want of a better expression, to overturn its ruling. So, I mean, this is a test of our democracy, and we live to see the outcome of this case. And I know Ghanaians and the media as well, we are all waiting with bated breath to know the outcome of the. In the meantime, we are going back to the courtroom to find out what is happening. My colleague Barbara Kuma is in the court and also monitoring the proceedings from the court. Yes.
We have the preliminary injunction now being forward. What is your expectation for today? Do you feel that as the court system?
I mean, that's what we are all expecting, that there will be finality to this matter. But for me, it's a learning process. Who's issues and matters. For years, the also to make provisions for cases that may arise in the future. So for and I know that Ghana will stand out tall in all whatever decision is taken by the court today would have future implications, whereby if such an occurrence happens, it's a learning curve. Ghana is a growing democracy, and every instance will test our resolve or our laws to see how far how strong they are, and to see how far citizens can push the law, can stretch the law. Yes.
So, if you are with us and you are joining the Supreme Court of Ghana, a case Afeyo Markin versus the there is from the speaker, Chief Justice Gertrude Araba Tokonu, to go with what Sarah says. It's poignant. This is a test of our constitution until parliament, and we saw a member from not the ruling party but a member from the opposition presiding. These matters wouldn't have come up, and so in all we see it as a test of the 1992 constitution and a test of the law. And so we are hoping that the rulings by the Supreme Court would inform and shape the nation moving forward. So from now we will leave the forecourt of the Supreme Court and in the chambers of the court itself.
Your Lordship, we are both Absunians, and we have agreed that 10,000 cedis fair based on the journey. Your Lordship, we are both Absunians from St. Augustine's, so 10,000 Ghana cedis.
Costs are assessed at 10,000 cedis.
We are most grateful.
Also, we are most grateful.
Application, which is to be, which has, yes.
Your Lordship, that application has been taken,
Overtaken.
overtaken by events.
So the application for,
What do you want to do to the application?
what do you want to withdraw it?
What do you want to do to the application?
Yes, withdraw it. Yes, madam.
This is for review. That's the of execution. Pending review. That's become. That one will not pay costs.
Your Lordship, I'm extremely grateful.
So the application for review, application for stay pending review is struck out as withdrawn.
Panel will be reconstituted. All rise.